this meeting to order, please? Will everybody please rise for the flag salute and remain standing for a moment of reflection?
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. The notice requirements of the Open Public Meetings Act of the State of New Jersey have been satisfied by the inclusion of the date, time, and place of this meeting in the notice of regular meetings adopted by this board on January 6, 2025. Such schedule and notice of meetings is posted at the Municipal Building, the Mount Olive Library, the Board of Education offices, and the 6 schools, was submitted to the Daily Record for publication on January 7th, 2025, and was filed with the Clerk of Mount Olive Township on January 8th, 2025. I direct that this announcement be entered into the minutes of this meeting. On November 17th, 2025, the Morris County Clerk issued a statement of determination certifying the election of John C. Petrie, Luisa Melendez-Canedo, and Lisa Brett for a term of 3 years for calendar year 2026. At this time, the Board Attorney will administer the oath of office to the newly elected members.
You do them all at once?
I was going to say, would we want to do it all at once or just one at a time? Either way is fine with me.
Do them all at once.
If you want to all come up, that'd be fine. You just stand in here, make sure you have your statement with you. You want to just raise your right hand and repeat after me. I state your name. Do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of New Jersey, and that I will bear true faith and allegiance to the same and to the governments established in the United States and this state, under the authority of the people, so help me God. I state your name. Do solemnly swear that I possess the qualifications prescribed by law for the office of member of a Board of Education, and that I am not disqualified as a voter pursuant to RS 19-4-1, nor disqualified due to conviction of a crime or offense listed in NJS 18A-12-1, and that I will faithfully, impartially, and justly perform all the duties of that office according to the best of my ability. So help me God. Congratulations.
Coming up? You guys coming up? Yeah, come on up. It's official now. They don't tell you that right away. It's official now. You should try doing it as an interim. They really they spring it on you. You're so cute. I can't. Okay, at this time, I'm going to ask for nominations for Board President for the 2026 calendar year. May I have a nomination, please?
I'd like to nominate Dr. Giordano for president.
I'll second it.
Anyone else? Could I get a motion to close nominations?
So moved.
Congratulations, Dr. Giordano.
Congratulations.
President.
Do we have to, don't we have to
You can
vote on
move
that?
into your spot.
There's nobody else running against you. Here.
Make some room over here, John. Good guy. Yep. I'd like to thank everyone on the board for their support. It means a lot to me. I'd like now to open up for nominations for Board Vice President.
I'd like to nominate Mrs. Figueroa for VP, please.
I second that.
Any other nominations? Seeing none, can I have a motion to close?
So moved.
Congratulations, Ms. Figueroa.
Thank you. I don't travel lightly. Bye, neighbor.
See you later.
Right now, next is the NJBSA representatives and Morris County ESC representative. Those have to be voted on. We'll do that at our next board meeting, and I'll solicit if any board members are interested in doing that. Traditionally, that's how we've done it. Presidential appointments, I don't see any of the committee chairs changing, but certainly if any committee members want to switch a committee, please email me. I will have that list out by Wednesday. So between today and Wednesday, let me know. And I just have to figure out, especially with Ms. Brett and Mr. Petrie, what you're thinking, committees you'd like to be on, and see how we do that from there. So certainly, everyone, I just think it's mid-year, or as a school year, to kind of move everyone in and out totally. If we make one or two changes, if someone wants to do something, that's fine, but I think consistency is the best way to go. And then let me know any liaisons, from town council, planning board, Recreation Advisory Committee, all that stuff. So if you could do that within the next 2 days, that would be great. We are not going to go confidential session right now. We are going to be moving confidential session to the end of our meetings. So we don't have to worry about that. And then I will turn it over to Mr. Geppert, who will give us our annual by code, our ethics training.
Well, thank you.
You have it,
And
yeah.
congratulations.
Thank you,
to
sir.
Okay, I do have a handout that you have in front of you, so you can take it home and read it at your leisure. I will move fairly quickly through this, but I did want to just point out a number of things to you. We do have to go over the School Ethics Act, and we'll do that at this time. So on page 2, it states the School Ethics Act. It gives you the citation so that we can move from there. Page 3, what I want to point out to you is the penalties for violating the act. The commission can recommend reprimand, censure, suspension, or removal from the board. So that is,
And real quick, Mr. Geppert, the board itself cannot issue anything to its fellow board members, right? It has to come
that's
from the Ethics
correct.
Commission.
There's
Okay.
case law saying that the board has no jurisdiction to take action against its members, that it's solely in the School Ethics Commission. And then on page 4, we start out with the prohibition on inconsistent interest. The main thing here under 12-2 is that a board member cannot be interested directly or indirectly in any contract with or claim against the board, nor could you be the mayor or a member of the governing body as well. So that's a general statute. On page 5, general principle here, coming out of 12-22A, is that board administrators must avoid conduct which is in violation of their public trust, or which creates a justifiable impression among the public that such trust is being violated. Now, starting with the individual points on page 6, we have subsection A, They're all listed at 18812-24.1. We do have to go over these 10 statements, and you do have to then sign a certification that you've gone over them. I will uphold and enforce all laws, rules, and regulations of the State Board of Education and court orders pertaining to schools. Desired changes shall be brought about only through legal and ethical procedures. And I've listed a case under each of these too that you can read at your leisure, but I do want to point out that these give examples of where board members violated. In this first one, they voted against 2 directives from the Department of Education on a send-receive matter, and that got them into trouble. Now, turning to page 7, number B, the second point is I will make decisions in terms of the educational welfare of children, and will seek to develop and maintain public schools that meet the individual needs of all children regardless of their ability, race, creed, sex, or social standing. This basically sets forth the principles about we're here for the benefit of the children and that we do not discriminate. And then there's a case underneath that as well. Now on page 8, we go to number C. This is an important one. I will confine my board action to policy making, planning, and appraisal, and I will help to frame policies and plans only after the board has consulted those who will be affected by them. So here, the case is an example of a DARE officer who was found that they couldn't also be a board member because the nature of their job was they were so involved with juveniles and students that it was a conflict of interest. So then turning to page 9, this point here, D, is I will carry out my responsibility not to administer the schools, but together with my fellow board members to see that they are well run. So this administrating the school tries to draw a line between what the administration does and what the board members do. The case under here found a violation where the board member bypassed the superintendent and demanded information directly from a district supervisor. And they were censured for doing that action. So that's a line that you need to be careful of. And obviously, I'm always here before and after board meetings, or during the meetings themselves. Feel free to reach out if you ever have any questions along those lines. Now on page 10, number E, says, I will recognize that authority rests with the Board of Education and will make no personal promises, nor take any private action that may compromise the board. So the takeaway here is making sure that you don't do any kind of promises or any kind of private action that compromises the board or puts the board in a bad position. The case here out of West New York showed where a board member unilaterally issued a Rice notice to the BA without notice to the board, and that was found to be inappropriate. Now on page 11, we have subsection F. And this one says, I will refuse to surrender my independent judgment to special interest or partisan political groups or use the schools for personal gain or for the gain of friends. So you have to be careful here about not surrendering independent judgment to special interests or political groups. And you also cannot use the schools for personal gain or the gain of friends. And this is an example here where they did not violate it in writing an article to the letter to the editor. But still, that's an area that you have to be very careful of. Now, turning to page 12, this is the confidentiality provision. And this under G states, I will hold confidential all matters pertaining to the schools which, if disclosed, would needlessly injure individuals or the schools. In all other matters, I will provide accurate information and in concert with my fellow board members, interpret to the staff the aspirations of the community for its school. And here is a case that we should look at, and you should be aware of it. The board member here violated this section when he intentionally informed members of his immediate family of an incident involving a student which resulted in discipline. The information was subsequently shared with countless others. Part of this was a board member texting to his son and other family members something involving a student in discipline. The son, of course, immediately sent it to everyone he knew, and it just went throughout the entire town. Board member was censured for doing that, and that's something that you need to be careful of. Turning to 13, subsection H, I will vote to appoint the best qualified personnel available after consideration of the recommendation of the Chief Administrative Officer here. So this point is one that stresses taking action on voting for personnel after considering the recommendation of the superintendent. It's an important point. This case does show that a board member is permitted to table appointments with the board if they want to ask for additional information, but it must not be done for nefarious reasons. So we have that basis there. Then on page 14I, talking about supporting the school personnel, it says, I will support and protect school personnel in proper performance of their duties. And in this case, they found it actually wasn't a violation here because the board member commenting about the board president, and they said that technically it wasn't school personnel. But you need to be very careful there when speaking about school personnel. We're here to support them and protect them in different ways. Now turning to 15, this is the last one in this section, J, and it says, I will refer all complaints to the Chief Administrative Officer and will act on the complaints at public meetings only after failure of an administrative solution. So the idea here is the chain of command and referring the complaints to the superintendent to give them an opportunity to act on it. And the idea, the board, sort of the judge of last resort, you act on complaints at public meetings only after there's been a failure of an administrative action on that. And the case down here shows where a board member sent a series of emails to the superintendent, football coach, board president, board council, directing certain actions to be taken by an administration. They found they violated that provision and they were censured. Now on page 16, I'm just including the conflicts of interest chart. We're not going to go over them in detail here. It comes out of Advisory Opinion 2417 and relates mainly to those board members who have a current member of the family who work in the district or with the local union, or board members who have a current member of their family who's involved in another school district in a statewide union. So that's just something to be aware of, and we can talk about that, and I'd be glad to talk with individual members if they fall into either one of those categories. Now, moving on to the prohibited acts and the conflicts of interest, now that we've finished the 10 main code of ethics provisions that you certified to, it's important that you're also aware, at least briefly, that there is an additional statute, 12-24, that lays out potential conflicts of interest. And Part A here says no school official or member of his immediate family shall have an interest in a business organization or engage in any business transaction or professional activity which is in substantial conflict with the proper discharge of his duties in the public interest. So the whole idea about not having a conflict with discharge of your duties. The advisory opinion here that I put in talks about a board member who owned a private business, and they were told they would violate it if they had that involved with their board position. So that's something to be aware of. Page 18, number B, talks about no school official shall use or attempt to use his official position to secure unwarranted privileges, advantages, or employment for himself, members of his immediate family, or others. So as you see, the phrases are somewhat general, and that's why it's always good to probably err on the side of caution. Here they say you can't use your official position to secure unwarranted privileges, advantages, or employment for yourself or members of your family. And here is a case where a board member made public comments about a candidate, and they damaged the board candidate's reputation. And this was found to be a violation, so you have to be careful with that. Page 19, Part C, no school official shall act in his official capacity in any matter where he, a member of his immediate family, or a business organization in which he has an interest, has a direct or indirect financial involvement, key word here, financial involvement, that might reasonably be expected to impair his objectivity or independence of judgment. No school official shall act in his official capacity in any matter where he or a member of his immediate family has a personal involvement. here the key phrase is personal involvement, that is or creates some benefit to the school official or member of his immediate family. The example here, the Brogan case, the board member attended closed session where litigation was involved and she was a party where it was discussed. She didn't recuse herself. This was found to be a violation. Now turning over to page 20, we have subsection D. And this talks about no school official shall undertake any employment or service, whether compensated or not, which might reasonably be expected to prejudice his independence of judgment in the exercise of his official duties. The case that we discussed before about the DARE officers cited again here, they found he would violate this provision as well. They did note that not all police officers are barred from serving as board members. You can. It's just because his assignments required extensive daily interaction with the schools, district personnel, staff, students, and parents, his role presented an inescapable likelihood of conflicts. So on page 21, subsection E, this one talks about no school official or member of his family or business organization which he has an interest shall solicit or accept any gift, favor, loan, political contribution, service, promise of future employment, or other thing of value based upon an understanding that the gift, favor, loan, contribution, service, promise, or other thing of value was given or offered for the purpose of influencing him, directly or indirectly, in the discharge of his official duties. This is basically the bribery provision. This provision shall not apply to the solicitation or acceptance of contributions to the campaign of an announced candidate for elective public office if the school official has no knowledge or reason to believe that the campaign contribution, if accepted, was given with the intent to influence the school official in the discharge of his official duties. So there is a carve-out provision in the second half of this section permitting the campaign and political contributions. The Rubino case that's cited down here below, the board member was found violated. This section, they sent emails soliciting campaign contributions to 3 district employees at their district email addresses, and they actually were suspended for 6 months for doing that. So that's something that should not be done. Page 22, subsection F. No school official shall use or allow to be used his public office or employment or any information not generally available to the members of the public which he receives or acquires in the course of and by reason of his office or employment for the purpose of securing financial gain for himself, any member of his immediate family, or any business or organization with which he is associated. So there, once again, the confidentiality provision that you have to be careful of. On page 23, subsection G, no school official or business organization in which he has an interest shall represent any person or party other than the school board or district in connection with any cause, proceeding, application, or other matter pending before the school district in which he serves, or in any proceeding involving the school district in which he serves, or for officers or employees of the New Jersey School Boards Association, any school district. This provision shall not be deemed to prohibit representation within the context of official labor union or similar representational responsibilities. The advisory opinion here has an example that a board member may serve as president of the local PTA, but they have to make sure that they do not represent the PTA before the board on any matter. So they would have to recuse themselves in that particular situation. As we move along towards the end, subsection H, no school official shall be deemed in conflict with these provisions if by reason of his participation in any matter required to be voted upon, no material or monetary gain accrues to him as a member of any business, profession, occupation, or group to any greater extent than any gain could reasonably be expected to accrue to any other member of that business, profession, occupation, or group. So the idea is that they would not benefit any more than anyone else in the group. The advisory opinion here has the example where a board member whose children attended the district high school were permitted to discuss and vote on a proposal to give greater weight to more academically challenging courses. but they were not permitted to vote on whether they could make such proposal retroactive when the retroactivity would give their children a greater benefit. So the individual facts sometimes depend on that. Subsection I, no elected member shall be prohibited from making an inquiry for information on behalf of a constituent if no fee, reward, or other thing of value is promised to, given to, or accepted by the member or a member of his immediate family. And in this case, they found that a board member violated the act when he sent an email to the superintendent that was critical of the superintendent's handling of a matter involving the board member's wife, a teacher in the district, in an attempt to secure an unwarranted privilege for his wife with respect to the disposition of 2 days of leave time. So this case is an example of a problem that would come up if a board member tried to direct the superintendent to do something regarding a spouse who's an employee in the district. In J, on page 26, nothing shall prohibit any school official or member of his immediate family from representing himself or themselves in negotiations or proceedings concerning his or their own interests. This is a safe harbor for parents, the school board members, that they obviously can advocate on behalf of their children. The example here, which went to the New Jersey Supreme Court case, Kennedy with the Sea Isle City, a board member is not disqualified from office by filing a special education due process request. The court said you can do that, but in this case, the board member got into trouble and was actually removed from office because their due process request included a request for specific monetary relief, money, demand for payment to the board member's spouse for services provided to the son. So that's where the clear line's drawn, that you get in trouble once you go after the district for money, things of that sort. K, we're going to skip over in 27 because that just deals with employees of the New Jersey School Boards Association. So that brings us to the end of the prohibited acts. I did want to just give you 2 or 3 additional slides on things with social media that I want to bring to your attention because in addition to all the other obligations as a board member, social media brings additional things to be concerned with. So in page 29 and 30, I have stated the Mount Olive board policy for you, 169.02 on board members' use of social media. And just going through them in general, the main thing is not to post anything that violates the district policies. Number 2, to avoid making defamatory statements about the board, the personnel, etc. 3, not to disclose any confidential information. 4, not to use or refer to your Board of Education title or position when soliciting for a business organization, as well as not posting any confidential information regarding the board. And over on page 30, it finishes 5, to refrain from having communications through social networks with other board members. And as we know, you can have a violation of the Open Public Meetings Act if a quorum of the board is discussing things outside of the board meeting. 6, not responding to any postings regarding Board of Education or school district business. And you shall refer such questions or inquiries to the superintendent of schools to address as appropriate. And the last one, not posting any information on a social network determined by the New Jersey School Ethics Commission to be a violation of the New Jersey School Ethics Act. Now, in 31, you hear quite a bit about a disclaimer for board members when they're dealing with social media. We've discussed this before, particularly for the new people. This is a new area for the Smelnick case. They now require board members to use the following prominent disclaimer when making or responding to a social media post, community pages, or other things that are involved in the public. And what you do in large letters, you state the following statements are made in my capacity as a private citizen and not in my capacity as a board member. These statements are also not representative of the board or its individual members and solely represent my own personal opinions. And that's to go with the board policy that the board has the authority to speak on an issue, but the individual board member does not. You do have a right to have your opinion on something, but when you post on social media, you write a letter to the editor, you do anything along those lines, You don't want to mislead the public into thinking that my opinion is really what the board's opinion is on something. So I've added one or two cases here just to show that even where they use a disclaimer, you can still get into trouble. So I hate to be full of bad news here, but it's sort of, that's what we do as attorney. In the Leonard case on page 32, this board member did use the disclaimer, but then they went on to violate the act because they posted anti-Muslim statements, and the board member was found to have engaged in private action that may compromise the board and could be viewed as violating the public trust. The School Ethics Commission felt that their comments about Congresswoman Omar and other people and a doll and violence was way over the line, and they felt that Muslim students would not be comfortable in feeling that they had a fair opportunity from that board member. So that was something to be careful about, even when they did a disclaimer. And then on page 33, here, Treston in Randolph, he did put a disclaimer statement in advising that he was writing on his own personal behalf, but that wasn't sufficient to insulate him from censure, because then he went on, and the content of his statement, where he endorsed two candidates and spoke out against another one, the commission concluded even if an appropriate disclaimer is used, a school official must never negate the import of the disclaimer by proceeding to discuss board matters in a way that leads members of the public to believe the individual is speaking on behalf of the board. So here, even if you say a disclaimer, if you start talking about the board and the board and the board and matters that the board has discussed and done and things like that, there were multiple references to the board and board matters in this, and it led the commission to feel that any member of the public reading that would think that the board was actually doing the endorsement along those lines. And then finally, I just added on page 34, the danger too with emails. I don't think we can discuss this too much. In this Lynch case, the commission determined that a board member failed to maintain confidentiality as required by the act when he replied all to an email. Now, the email contained his opinions on a controversial issue, and they were actually accidentally sent to a district parent, that he thought he was just responding reply all to the board members and superintendent, but it had been initiated by a parent, and so the parent was still on that chain, and all of this confidential information was given to them. The commission found because the board member did not intentionally include the parent on the email, he was subject only to censure as opposed to a more severe penalty. So sorry to race through that, but I did want to just touch on the important points for you. Feel free to look at this, and I'm available at any time to discuss, specific situations in that.
Any questions from the board? For Mr. Geppert? Seeing none, thank you, John.
My pleasure.
Make sure everyone signs that, and we can pass them, drop them off to Ms. Schoening, or you just want to pass them down now? If everyone has them, you can just pass them down.
So we'll just pass these down. Would you like a pen?
Yes.
Oh, you got
Well,
one?
good.
Okay.
John wants to make sure that I sign.
We're moving right now to public comments on action items. 6.1, members of the community may comment on any action item included on tonight's agenda prior to board discussion. You're looking at 7.1 all the way down to 10.1. So anyone come up to the mic, state your name and address for the record on action items and action items only? Seeing none, closing the public comment. Can I have a motion for consent agenda approval on the action items?
So moved.
Need a second?
Second.
Thank you. Ms. Aquino, would you make the motion? 9.1 all the way down. I think I messed that up.
7.7.
Oh, sorry, 7.1, thank you. From 7.1 all the way down to 10.1.
Certainly.
Messed that up.
On behalf of the superintendent, I'd like to make a motion to approve action items 7.1 through 10.1. 10.1. Thank you.
You want to second that again?
Second.
I messed that up, guys. I apologize. Any questions or comments from the board?
Shake the rust off.
I know, I got it.
Rusty.
Seeing none, no comments, closing, roll call, Ms. Schilling?
Mrs. Aquino?
Yes.
Mrs. Brett?
Yes. Yes.
Mrs. Figuera?
Yes.
Mrs. Fitzgerald?
Yes.
Dr. Giordano?
Yes.
Mrs. Melendez?
Yes.
Mrs. O'Neill?
Yes.
Mr. Orzillo?
Yes.
Mr. Petrie?
Should I abstain on the minutes because I was not a board member?
Yes, and actually,
You can.
yeah, and actually, Ms. Brett should go back, change Ms. Brett to your vote. I didn't realize that, I just thought of that now. Yes, they should both abstain on that, on the minutes.
So yes, everything, abstain for 8-1 and 8-2.
Same.
Okay.
And now we're moving to public comments in general. Students, parents, employees, and community members may comment on any item of interest or pertaining to the Mount Olive School District. Please come up, state your name and address for the record.
Good evening, everyone.
Happy New Year.
Happy New Year. President Giordano, members of the board, members of the community, staff, and welcome guests, in particular, glad to see members of MOTSD. My name is Gita Vogel. I live at 48 Junegrass Way, Panther Valley, Alamucci. And I am in my 7th year as PSA representative for MOTSD. I have 2 reasons for being at the mic tonight. One is to congratulate the new board members, to wish you all well in all the decision-making that is forthcoming on behalf of the wonderful community we call Mount Olive. Welcome to the new members, and you will see what an august group it is. And the second is just to say thank you to members of MOTSD. You will get to know them as well. They work tirelessly on behalf of the students, the staff, and the Mount Olive community. A great place to be. So once again, Happy New Year. I've been on hiatus with, recovering from this so-called easy surgery. So don't believe them when they tell you that. But nonetheless, thank you all for all of your accommodations during these past 7 years.
Thank you.
Happy New Year.
You look great.
Thank you.
Good evening, nice to see you all again.
Hold on a minute, hold on a minute.
Hang in.
Come on, man.
Yes.
Is that up for you, sir?
I'm a little taller than you. I'm very excited about this board. First of all, I want to congratulate Dr. Giordano and Ms. Figueroa.
Excuse
You
me.
have some veteran leadership
Can
there.
you state your name?
Yeah, name and
Oh, I'm
address,
sorry,
sir.
Tony Strelacci, Knollwood Road Leaders. Thank you. And I want to congratulate Mrs. Melendez for her re-election. And welcome back John Petrie, a former board member, and a new board member, Mrs. Brett. Now what you have to do, this board has to do, is it has to coalesce into one mindset. You have to talk to one another, you have to confide in one another, work with one another, work with the administration, and the administration has to work with you. Because in addition to every exigency that's going to occur during this school year, you've got a couple of major issues you're going to have to deal with. One of those I would like to talk to you about tonight, and that is our overcrowding in our schools. Now, I know you've been talking about it, and I believe the administration has discussed this with the town administration. But there's no doubt in my mind, folks, that this year, you have to go out for a referendum. There is no doubt in my mind. I'd just like to take a moment, if you would, please, and I'd like to give you a little history and some suggestions. When I came to Mount Olive, we were growing so fast, we literally had to lease space in a church and in a bowling alley for classrooms. And all during the following years, the community of Mount Olive was so supportive of the district. even during, it's always tough times, and always when people are struggling. And we built the Upper L School, we built the Mountain View School, and closed the Bud Lake School. In the Flanders School, we built, the Bud Lake School, the Flanders School, then we built the Sand Shore, we closed the Bud Lake School. Then we built Mountain View North. Then we built a high school. Then we added an addition onto the middle school. Then we added an addition onto the high school. We kept doing this and doing this and doing this. And the community kept supporting us. Now let me take you up to 1990 and 1991, which is when I first got on the board. In those days, the budget was different than it is now. There were two segments to the budget, the capital expenditure, capital outlay. You had to vote for both of those. Capital expenditure, as you know, would be your operating expenses. Capital outlay, of course, you would know would be what your capital reserve is account today, where you do your building, your equipment, and everything. Well, you had to vote for both of those, and the people did, and they kept voting for it, and they kept supporting us. But in 1990 and 91, we had to put an addition on to our middle school, in the back of our middle school. We already put one in the back of the middle school in the 80s. Now we had to put one in the front of the middle school in the 90s, and there was a reason for that. But in those days, we had no cap on our capital outlay, which we have today. And we had the money in there. So we took $600,000, it was $100 million too. We took $600,000 from the 90 budget and $600,000 from the 91, and we were able to pay that without going to referendum. But now we saw and the reason why we did that, we saw the growth continue to come, and we were so loaded in our elementary schools. We did that because now we were going to take the 6th grade level and move it up to the middle school and be 6th, 7th, and 8th. Let me tell you something. I've been in attendance in board meetings for over 750 meetings. I have never seen a meeting that was as full as the one when we announced 6th graders were going up to the middle school. The parents were irate, they were upset. They did not want 11-year-olds going to school with 15-year-olds. But we had an out, and we explained it, and they lived with it. We had 2 additions we put onto that middle school. You know today as CMS. The one in the back and the one in the front. And we explained to them, they will never see those 8th graders. The 8th graders will be in the back, the 7th graders in the middle, the 6th graders in the front. They will not have lunch together. We kind of appeased them, and thank God we got through with that. And now we were able to alleviate some of the overcrowding in our elementary schools. But we knew what was coming. We saw it continue to build. I mean, with all the apartments we have in Oakwood Village and Village Green and Steadwood Village, and all the developments that kept building and building and building, we knew what was coming. So in 1997, we came out with a referendum, a $40 million referendum, which was the largest in Morris County at that time. Now, I've been involved with 4 referendums. Two passed, 2 failed. And as you know, when you have put out a referendum, there are 2 things. The core of that school was built in '67, and the hallways were narrower than they are today. That was the code then. And I watched those kids in that hallway, and we prayed that never did we have a problem, because they were shoulder to shoulder changing classes. We didn't want to see that happen again. So we knew we had to build a new middle school and then capture the old school as an elementary, and that would solve our problem. So we went out to the people and we showed them what we were going to do. In addition to that, save them some money, because we were going to join Mountain View North with Mountain View and save all the duplicated administrative costs. So that was going to help. And we were able to show them some undeniable need that was there. It was probably 90% of that referendum, and it passed. We then knew eventually, as the bubble kept going up, we were going to have to do something at the high school. So in 2003, we came out with a $49 million referendum to expand the high school. We only probably at that point had a 50% undeniable need, because we built a performing arts center, and we put turf fields in and what have you. But we got a break that year. That was the year that the state said, we're going to put in $8.6 billion for school construction and reform and everything. And we were going to get approximately 23% or $13 million. I'm using these figures, but I know I'm in the area someplace, but you know, your mind goes there, but I'm pretty close. We were going to get $13 million. So we only had a 50% undeniable need for that referendum. But who could turn down you're not going to get that money again, $13 million, so it passed, and it was great. Now come along, we're still getting loaded up in our elementary schools. So around 2017, 18, we said, we're going to put classrooms on the back of Sand Shore. We need more elementary room. But we also said, let's get a kicker in there. Let's get a little help. So we're going to also put into that referendum a separate question, full day kindergarten. Don't ever do that again, because we insulted the public. We gave them an ultimatum. We said, if you vote for this, you can have that. But if you don't vote for this, that fails. Don't ever do that again, because we learned the lesson at that point. Now we fast forward to 2023, this past election. We're crowded again. We have to do something. And so we come out with a $50-some million referendum. But only about 40% of that was an undeniable need. We thought more, which I'll explain in a minute, and that was we were going to put on 8 classrooms in Tents Road, 8 classrooms in Sand Shore, and we were going to do 2 classrooms plus a all-purpose center in the middle school. That was roughly $21 million, or 40% of that referendum. But we also told them, look, our schools are 40 years old. We're putting more need into the other part of it because we need roofs, we need ventilators, we need HVAC units, and so on and so forth. And that was a need for us. We learned a new term, because when that thing failed, I spoke to a lot of people and they said, you know something? Those things should have been put in your budget and done every year. And I tried to explain to them, look, our budget's capped at 2%. We can't, the money is not there. We are doing other things. But we just didn't have the money to do it. They said, wait a minute. You had the money to build a stadium. You had the money to build a sound recording station. You had the money to build, at least purchase a dome. You had that money. Why didn't you put that into the roofs and everything at that time? So you learned something. We learned a new term, a deniable need. And that's what that was. So what I'm trying to tell you is this. You definitely have to, listen, when we had the 2022 demographic study, it showed we were over capacity and end. This is 3 or 4 years later, folks. I can imagine what's going on in that school. Before I got off, the last tour that I took in the schools, they were teaching in the hallways. They were doing in an alcove. They had musical instruction. I talked to one principal. She said, "Listen, I need to put on another section, but I don't know where I'm going to put them." So it's got to be even worse now. It must be 2 years, 3 years later. You need to go out for referendum this year, but when you go out for referendum, go out for 100% undeniable need. Don't put all this other stuff in there, because the folks are going to knock it down. You have to realize when you go out for a referendum, you have a core 25% vote against you to begin with. That's number one. 25% core vote against you. Now, one of the biggest mistakes we made in this last referendum, you have 5,000 students in this class, in this school system. If you only used one parent, not 2, you got 5,000 votes. If you allow that one parent to have 2 students, you have 2,500 votes. Besides some of the other votes you're going to get. In this last referendum, we got 1,500 yes votes. So when you go for this next referendum, you zero in on the parents of the kids that are in school now. That's the people you have to talk to. Those are the people you have to convince. because you're not going to convince the people who do not have any more people in the school, kids in school, and that's where you're going to have to go. But folks, I'm telling you right now, you have to go out this year for a referendum. You cannot let it go any longer. It's been 3 years since the last one. And if you don't do it now, you're just going to be really in trouble. Thanks for your listening.
Thank you.
Thank you.
Thank you.
Closing the public comment. Any board comments? Board members may comment on any item of interest pertaining to the Mount Olive School District. We'll start down with Mr. Petrie.
Just want to say thank you to the voters to get me back on the board. I'm looking forward to the next 3 years. And just found out from Mr. Stansbury, the alumni is tomorrow. I love that event, so hopefully I will be able to make it. That's it. Thank you.
Ms. Brett?
Same, just thank you to the voters and my family and my friends who came out.
Ms. Aquino?
Just want to congratulate Mr. Petrie and Ms. Brett and Mrs. Melendez. Welcome back again. And we're going to have a great year.
Ms. Fitzgerald?
We're going to go with ditto. Everybody said everything.
Ms. O'Neill?
And ditto, and congratulations to President, Vice President.
Mr. Rosillo?
Well, congratulations. I'm looking forward to working with everybody. And a good year. Thanks.
Ms. Melendez?
Thank you for the voters for pre-election and the vote of confidence, and welcome to our new board members. I hope we are going to work closely, all of us, and congratulations to the vice president and to the president. And thank you so much, Mr. John Jeppert, for always your orientation and wise words.
Ms. Figuera?
I'm going to keep it short and sweet because I'm losing my voice. But I just want to thank everybody for the vote of confidence. I will work to the best of my ability to keep our district moving forward and always putting our children first. And I thank all of you for putting your faith in me.
I'd like to congratulate the newly elected board members. Ms. Figuera on Vice President, I look forward to working with you this year, and to the board members as well for confidence in me as the board president. With that being said, I will need a motion to move to confidential session.
So moved.
Is the statement on here? Yes. Resolved that the board meet in confidential session for the purpose of discussing personnel, matters of attorney-client privilege, pending or anticipated litigation. And be further resolved that the matters discussed in confidential session be disclosed to the public when reasons of confidentiality no longer exist. Action will not be taken. Usually we say may be taken, is not being taken today. All those in favor?